for your egg donation and surrogacy journeys. First and foremost, Canada has clear and strong legislation federal legislation saying that surrogacy is legal. We also have legislation on a provincial level in British Columbia, Alberta, and Ontario, which states that a person who donates human reproductive material for the purposes of somebody else's conception is not a parent of a child that is born of that donation, despite their genetic connection. Canada has an excellent social healthcare system, which will cover the cost of your surrogate's maternal care, which has been in place for many years. Also in Canada, as in, I have just heard, as in California, all families are welcome. It's illegal to discriminate against any other party in Canada, and that includes discrimination based on sexual orientation. The federal government does not care whether you're single, heterosexual, bisexual, lesbian, or transgendered. All parties have the right to have children, and that right is protected and supported. As in the US, as I've heard from my contemporaries here, there are 3 stages, legal stages, that you're going to deal with in Canada. You would generally have an egg donation agreement if you need an egg donor, and a surrogacy agreement, and then you're going to be dealing with your parentage process or your exit process at the end of the day. We deal with, in Canada, 2 types of egg donation agreements, anonymous and known agreements. Obviously, in one, the identity of your donor is known, and in the other, it's anonymous. What decision you make with respect to that, whether you're going to have anonymous or known donation, is a personal decision, and you should have a chat with your lawyer on the pros and cons of that. I'm not going to necessarily get into that, but on a high-level general approach, the issues that your egg donation agreement are going to address are to ensure that your donor is being as truthful as possible regarding any information you are receiving concerning her genetic and familial background. The agreement will set out that despite the genetic connection between your donor and your child, that the child is your child, and that the donor and the partner, if she has a partner, agrees with that intention. The agreement is going to indicate that it's an altruistic process and not a commercial process. It'll require your donor to advise through either you guys directly, if it's a known donation, or through an agency or a clinic, if there's been any medical issues following the donation. As well, if your donor has children going forward, she will also advise you, or should advise you through the clinic, the agency, or you directly, that she has had children, and it'll require you guys to do the same. Perhaps the most important part of any egg donation agreement that we deal with in Canada is the issue of liability. It will state that a donor is coming forward freely and voluntarily without any economic or emotional pressure for this donation, and she would release you of any liability should anything occur during the donation. So moving on to the surrogacy agreement, you must have a surrogacy agreement to engage in a surrogacy practices in Canada. And your surrogacy agreement is going to set out the intentions of all parties. It's going to require you to address important issues such as termination, selective reduction, conduct during the pregnancy, where a surrogate can travel during the pregnancy, and any dispute resolution mechanisms should there be a dispute. However, perhaps the most important part of this agreement, and where Canada really differs from the states on surrogacy issues, is the issue of reimbursement or expenses or compensation. In Canada, it is illegal to pay somebody to carry your child or to donate for you, as a matter of fact. It is legal to reimburse your donor out-of-pocket reimbursable expenses. Your surrogacy agreement should be really clear regarding what expenses are reimbursable and how that's going to happen. Currently, the legislation in Canada says that you are entitled to reimburse out-of-pocket expenses, but there's no real definition as to what is a reasonable expense. That may change, but currently there is no definition. So the practice that's developed in Canada over the years is a test, I guess, the council used, is that surrogates may be reimbursed an out-of-pocket expense that has been incurred directly related to the pregnancy, as long as there's a receipt or something in writing to back up that expense. Any expense that a surrogate has, regardless of a pregnancy, such as a mortgage payment or rent, is not a reimbursable expense. I always suggest, and my contemporaries in Canada, I'm sure, suggest the same, that all clients work with competent surrogacy agencies throughout the journey for any number of reasons. However, one of the most important reasons from my perspective that an intended parent, especially international intended parents, work with an agency is because of the issue of reimbursement of expenses. That is, the liability regarding the payment of expenses lies with the actual payment, not with receiving the money. So it's important that you engage in a reputable agency to help you facilitate through the reimbursement of expenses and the scrutiny of receipts. So the final part of the process would be the exit process. As international people, there are three provinces in Canada which are good provinces for you to have a surrogacy journey in, and they would be British Columbia, Alberta, and Ontario. British Columbia, all destinations, it's a post-birth process. So when your baby is born in British Columbia, a statutory declaration would be signed between the intended parents and the surrogate saying that you guys are the parents and the surrogate is not. With that document, you go to Vital Statistics and you will get a birth certificate. And once you have your birth certificate, then you can apply for a Canadian passport. You can apply for a Canadian passport on a rush basis if you pay a nominal fee. And once you have your passport, you're off home. In Alberta, it's not a statutory declaration process. You have to get a court order. So there is the day after or the day your baby is born, somebody will attend at the hospital with a consent order saying that you guys are the parents and the surrogate is not. And that order will be sent to one of three judges that are assigned in Calgary to deal with these issues, and you will get your consent order back in probably 2 or 3 days. Once you have your consent order, you again take that order to your Vital Statistics to get your birth certificate, and following your birth certificate, you will get your passport. There's new law in Ontario, which is great. In Ontario, you used to have to actually physically attend court and ask a court to grant an order for parentage. That is now gone. Cindy Wasser is here in the room. Cindy, stand up so I can introduce you to everybody. Cindy is a lawyer in Ontario, a senior fertility lawyer and one of my mentors, and she was pivotal in this change, legal change in Ontario. The new act is called All Families Are Equal Act, and that act has taken the parentage process out of the courtroom and made it a guaranteed parentage process and a statutory declaration process. So once your baby in Ontario is born, 7 days after that baby is born, there is a statutory declaration signed. You take that statutory declaration to Vital Statistics. Within approximately 5 days, you'll get your birth certificate, and then after you get your birth certificate, you get your passport and you go home. In all provinces that I've addressed, BC, Alberta, and Ontario, the process takes about 2 to 3 weeks.